I first met Margot Bagley 6 years ago at an intellectual property conference at Cardozo School of Law, on patenting people, in fact. Like the other speakers on our panel today, Margot Bagley is a polymath with a background in chemical engineering as well as in law. She currently serves on the Faculty of Law at the University of Virginia, where she teaches courses in patent law, international and comparative law, intellectual property, and property law. But she's also taught international patent law and policy courses in Germany, China, and Singapore. She is a member of the board of directors of the Patent Foundation and also served on the National Academy of Science Committee on University Management of Intellectual Property. Before pursuing her celebrated career as a legal scholar, she worked as a product research and development developer with Procter & Gamble Company, where she was named Product Development Excellence Rookie of the Year and was co-inventor of a U.S. patent for improved peanut butter. Later, she worked as a senior research analyst for the Coca-Cola Company. Through her corporate experience, she developed an interest in law of intellectual property. Her credentials are too numerous to list here, but I'll note that in the papers that I've taught of Professor Bagley's, I have especially appreciated her focus on ethical and moral issues associated with intellectual property. So we're very fortunate to have her here today, and from her a paper titled Changing Tides or a Drop in the Bucket, Challenges to Plant Breeding in the U.S. and Abroad. So welcome, please, Margot Bagley.
Thank you so much, Clark, and I'm delighted to be with you all today. I wish my voice had chosen to join us. However, it's in absentia, and I'm just really sorry for that, but this is, I think, just what it's going to be. The really difficult challenge is Saturday night I'm supposed to be singing in a reunion concert. Now, I normally sing tenor, but I'm either going to have to lip sync or sing bass. I don't know what's. So this is what we've got today. All right, so this is a topic that I find really interesting and I think is probably appropriate, hopefully interesting to this audience. Looking at, largely be focusing on issues related to plant patents in the U.S. and abroad, but I'll also bring in some other types of morally controversial biotech inventions as well. I want to give a little background on how we got to where we are, talk about a couple of specific plant patent cases, some of the consequences arising out of those cases that I think provide implications for where we're headed in terms of whether we're going to continue to see these challenges to plant patents in the future. All right, so it's been talked about. I have a couple of patent primer kinds of slides in here, but I think Professor Johnson did a wonderful job of going over the types of intellectual property, so I'm not going to spend a lot of time on that. A patent, we do use the term to refer to both the paper document that discloses the invention as well as the right that the government grants to a patent owner to exclude others from practicing their invention. Can you hear me? Am I loud enough? Okay, great. And as was noted, this is a negative right to exclude others, not necessarily a right to practice your invention for a variety of reasons. It is authorized by the Constitution and is supposed to be for limited times and is supposed to result in promoting the progress of science and the useful arts by providing this incentive to inventors to disclose their inventions in a way that others can build on them. And to a large extent, patents have had that effect, particularly in the chemical and pharmaceutical industry, where companies tend to make much, much more from obtaining patents and enforcing their patents than they do spend defending against patent litigation. But patents don't always have that effect. This is from a recent book, James Besson and Michael Moyer, economists, and actually Moyer is an economist and a law professor, looking at some of the problems with the patent system and ways in which patents fail to meet the objectives of incentivizing innovation and giving proper notice to third parties so they can adjust their conduct accordingly. and outside of the chemical and pharmaceutical industry. Unfortunately, companies often spend much more defending against patent litigation than they make from acquiring patents, and that has raised a whole nother set of issues. Something you might have seen is this chart of all of the patent suits that are going on with the mobile phone technology. Everybody is suing everybody else. There are lots of costs associated with that of course get passed on to consumers and the products that we purchase, but it's not necessarily going to R&D and to creating wonderful new things. It's going to lawyers, and that's not necessarily a bad thing either. Sorry, no, I just had to throw that in. Okay, so going to the kind of the beginning of our topic for today. That was just to make the point that even companies don't always benefit from patents, but there are certainly public concerns related to patents as well. So the patenting of biotechnology inventions really started, there were a couple patents before that, but with the Diamond v. Chakrabarty case, where Dr. Chakrabarty invented a new bacterium that was able to chew up more types of oil, more types of hydrocarbons. And you couldn't find a bacteria in nature that would do it. It was supposed to be more useful for treating oil spills. And actually, it was used in the Exxon Valdez spill. Not for very long or for very well. Apparently, they didn't chew up a whole lot. Like maybe in a day, the bacteria would chew up like a teaspoon worth of oil. Nevertheless, it was really important from a patent standpoint because in this case, the Supreme Court said that, yes, this is patent-eligible subject matter. This comes within the statutory language of a composition of matter. It's a composition of two or more compounds. We could consider it an article of manufacture because it was manufactured. And just looking at those dictionary definitions, this is patent-eligible subject matter. We don't care that it's living or non-living. All that matters is that there's enough human intervention involved in creating something that does not occur naturally. And the court took a very broad view of the patent statute, saying that Congress intended eligible subject matter to include anything under the sun made by man. Now, that is not exactly what Congress had said, but the Supreme Court ran with that, and they've been saying it ever since, and we've lived with the consequences. There are limits, and the court did note limits in that decision, that there are exclusions for laws of nature, natural phenomena, abstract ideas. So they pointed out that a new mineral discovered in the earth or a new plant found in the wild is not patentable subject matter. Einstein couldn't have patented E = mc squared. Newton couldn't have patented the law of gravity. Such discoveries are manifestations of nature, free to all men and reserved exclusively to none. However, in the United States, which is the law we're dealing with, these exclusions have generally been interpreted very narrowly by the courts. So it's really hard many times, at least until recently, to find something that would be excludable as natural phenomena or abstract idea. And this is partly because of a view that has existed since the beginning of our patent system in 1790. This is a quote from a paper talking about negotiations back at the Paris Convention in the late 1800s and the views that America had and that America was trying to get other countries to adopt regarding patents, that patents should be viewed as private property rights, not as these tools of public policy, and that they should be given strong encouragement. This American view toward patents, that patentees were public benefactors to be kindly treated, was novel. It stemmed from an actual faith that in a competitive economy, patents under the control of private owners would not be subjected to abuse. The files of the USPTO contain a constant reiteration of this theme. They reveal an absolute faith in the beneficent effects of an uncontrolled system. And this is an idea that has come down to us today, and there is a lot of resistance to putting limits of any sort on patent-eligible subject matter because the patent system has been seen as such a driver of innovation and success in the United States. But just as patent protection can be valuable, too much patent protection can be detrimental, or patent protection over the wrong types of things can be detrimental. So this broad view towards patent-eligible subject matter, and in conjunction with the Diamond v. Chakrabarty decision, has resulted in patents on a variety of morally controversial biotech inventions, transgenic animals, genetically modified plants, genes, cloning methods for mammals, which would include humans, human embryonic stem cells, mixed human-animal chimera. All of these types of inventions have generated concerns, often in the public and often by researchers in various fields, as to whether these are the types of inventions that we should be granting patents on, that the government should be granting these exclusive rights to. When we're talking about morally controversial subject matter, there are actually two widely different concerns. Some people are concerned that, or would prefer this research not to be conducted at all. And patents provide this government-granted incentive to engage in the research. So that's the patent problem. With other types of inventions, there's a desire for the underlying research to be conducted, but there's the idea it should be free for everyone to use, what was talked about earlier, the common heritage of mankind, not under the control of the patent owner. So these two very different concerns result, however, in a concern about patents on morally controversial biotech inventions. We have, at one time, we had a way of considering morality in granting patents, and it was through the moral utility requirement. Inventions are required to be useful in order to be patentable. And there was this decision by Justice Story back in 1817 saying, all the law requires is that the invention should not be frivolous or injurious to the well-being, good policy, or sound morals of society. The word useful, therefore, is incorporated into the Act in contradistinction to mischievous or immoral. And on that basis, the Patent Office and courts would deny patents or invalidate patents on a variety of morally controversial inventions like gambling machines, contraceptive devices, deceptive inventions. Over time, however, the Patent Office and courts became less comfortable making these sorts of ad hoc morality determinations. And it got to be that as long as an invention had one good moral use, you could get a patent on it even if it had other immoral uses. You could think of guns, for example, as an invention that has a good use, self-defense, perhaps, but then other bad uses as well. And so this rejection fell out of favor. You could generally find a good use for just about anything. However, when the Patent Office received an application back in 1997 for a human-animal chimera, and this is really just, I love this sculpture because it speaks for itself. Excuse me. We filed an application for a creature that would have a mixture of human and animal cells spread throughout its body. Excuse me. They had not actually made this creature, nor did they have any intentions of making one. You don't actually have to make an invention in order to get a patent on it. As long as you could write a description that would enable a person of ordinary skill in the art to make and use the invention, you can get a patent on it. And so that's what they did. And their goal was actually to get the Patent Office to make a statement about what the limits of patent-eligible subject matter actually are. They didn't want anyone to make this. So they're like, either the Patent Office will say, nope, you're not entitled to a patent, and we'll know that that's the limit. Or if they grant a patent, then we can at least prevent other people from making these types of inventions. They claimed a Hugh mouse, a Hugh goat, a Hugh pig, just all kinds of variations. That wouldn't have been terribly helpful because as long as someone could, there would be ways, arguably, to get around what was claimed there. But that was their goal. And the Patent Office, I found this out at the conference that Clark mentioned, the Patenting People Conference. Bruce Lehman, who was commissioner of the Patent Office at the time this application was filed, when I talked to him at that conference, he said, I was just indignant. I couldn't believe that someone would file an application not to get a patent, but to basically make this statement, and I was determined that patent was not going to issue, words to that effect. And the Patent Office did issue this media advisory It is a position of the PTO that inventions directed to human, non-human chimera could, under certain circumstances, not be patentable because they would fail to meet the public policy and morality aspects of the utility requirement. So here we see the Patent Office trying to revive that moral utility argument when they are faced with this very controversial invention, not so much because of the subject matter, but because of the way it was filed, why it was filed, etc. But that moral utility requirement really has no basis in U.S. law, certainly not after the 1952 Patent Act. This is from the Juicy Whip v. Orange Bang decision that the Federal Circuit handed down in 1999. They talked about the language that Justice Story had used and said this principle has not been applied broadly in recent years. Congress never intended that the patent laws should displace the police powers of the states, the powers by which the health, good order, peace, and general welfare of the community are promoted. And that case involved an allegation that the invention was deceptive. And they're like, there are other government bodies to deal with that. There's a Federal Trade Commission. If they feel that something's deceptive to consumers, they can deal with that. The patent statute doesn't say anything about morality. Useful, you can't read morality into useful. And so that, along with actually language in the Diamond v. Chakrabarty decision where the court said we really don't have the competence to address these moral issues about all the gruesome parade of horrible things that will happen if this patent is allowed to issue and this type of genetic research is encouraged. So bottom line, no basis for challenging the morality of inventions in the United States. And that's in part because when you look at the requirements for patentability, that invention has to be of the right type, machine, article of manufacture, composition of matter, process, useful, novel, non-obvious, and meet the various description requirements, there's nothing in there dealing with morality. And the patent statute actually says a person shall be entitled to a patent unless, basically, the Patent Office can prove that they're not. The Patent Office can't prove that they're not because the Patent Office doesn't have a statutory basis to do that. So I wrote an article a few years back called Patent First, Ask Questions Later, Morality in Biotechnology and Patent Law, pointing out that the United States had a de facto system of granting patents and then asking whether we should be granting patents on certain subject matter because scientists, by the applications that they were filing, pushing ever forward the boundaries, were deciding what the limits of patent-eligible subject matter would be. There was no basis for the Patent Office to not grant such patents. Excuse me. An example of that is the JEM Ag Supply versus Pioneer Hybrid case that I believe EDSI's litigated at the United States Supreme Court. This was a case where the Supreme Court, they basically took the language that they had stated in Diamond v. Chakrabarty, trotted it back out again and said, yep, it doesn't matter whether something's living or non-living. What matters is human intervention. And plants, seeds, asexually reproducible plants are patentable just like any other type of composition of matter. Taking a very broad interpretation of the statute, even though there are specific statutes relating to the patenting or protection of asexually reproducible plants and to the protection of sexually reproducible plants through the Plant Variety Protection Act, which has various built-in safeguards. The court says, no, those don't mean that Congress intended there to be any limit on 35 U.S.C. Section 101. I don't know how coincidental it is that the decision was authored by Clarence Thomas, who had formerly been an attorney with Monsanto. I'm just saying. Okay, so, excuse me, the U.S. approach, patent first, ask questions later, is in contrast to the approach taken in many other countries of actually having an explicit provision relating to morality. So the European Patent Convention, originally all it had was the first paragraph, European patents shall not be granted in respect of inventions, the publication or exploitation of which would be contrary to order public morality. After the EU Biotech Directive was passed in 1998, the European Patent Convention was amended, and so we have a non-exclusive list of some things that are considered immoral. Of course, it's tough to take the word morality and a patent examiner figure out, well, what does that mean? So this Rule 23D explicitly excludes as immoral certain types of things like processes for cloning humans, uses of human embryos for industrial or commercial purposes, processes for modifying the germline genetic identity of human beings. So a lot of the things that have been patented in the United States, not eligible for patent protection in Europe. For example, like human embryonic stem cells and processes for cloning human beings. I'm not going to take a lot of time with this because I've got a lot to cover. So in the U.S., after Diamond v. Chakrabarty, the Patent Office just moved forward with granting patents on all kinds of inventions, including transgenic animals. So the Harvard Oncomouse, designed to be a better test subject because it was more susceptible to developing cancer, they were able to get a patent on it in the United States back in 1987, I believe. The application had a much tougher time in the European Patent Office and in the Canadian Patent Office as well. In the European Patent Office, because of the Article 53A morality provision, the Patent Office, they went through a weighing exercise. We've got to figure out, when we're dealing with these higher life forms, the benefits and the disadvantages. And for this mouse that was susceptible to developing cancer, they're like, well, there's a strong interest in remedying cancer. Cancer is a really bad disease. They looked at environmental issues, and this mouse is going to be used in laboratory, not likely to escape and mate with field mice and create all kinds of problems. And in terms of animal suffering, they basically said more of the mice will develop cancer, so few of the mice will have to be used, so less animal suffering. I never really got that argument. And so bottom line, patentable. But interestingly enough, in a different, it didn't go all the way through to an application, but Upjohn had an application for a patent on a transgenic mouse that was a good baldness subject, so it would lose its hair, so good for testing baldness remedies. And the EPO, in going through this weighing, says, no, we don't have the same interest in remedying baldness that we have in curing cancer, no patent on that invention. And this also actually gets incorporated into the Biotech Directive and the European Patent Convention, the last line, modifying the genetic identity of animals, which are likely to cause them suffering without any substantial medical benefit to man or animal, and also animals resulting from such processes. Not a problem in the United States, patent all the mice you want. So, different approach, and also in the U.S., patents issued on human embryonic stem cell cultures, no problem, issues arise, people get upset after the patents issue in the United States, but here the patent applications were rejected, excuse me, first at the board level, then the enlarged Board of Appeal, which is the highest level in the European Patent Office, also rejected Worf's stem cell application. This hasn't only happened in Patent Office. The German Supreme Court rejected claims or upheld the revocation of claims in a similar application to a different applicant, where the invention required the destruction of human embryos. This case actually went all the way up to the European Court of Justice, which also agreed that under the Biotech Directive, these inventions were not patentable. And so this is the court and the Patent Office taking actually a very broad view of the language of this Biotech Directive, because it talks about uses of human embryos for industrial or commercial purposes. And Worf, which is the Wisconsin Alumni Research Foundation, made the argument that, well, we're not claiming uses of human embryos, we're claiming cultures, okay, compositions of matter. And the court, the board said, well, you have to use the embryos to make the culture, therefore that involves uses of human embryos for industrial or commercial purposes. We're not going to focus on the particular claim category that you're using. All right. Another situation, and this is the Canadian court dealing with the question of the patentability of this Harvard Oncomouse. In Europe, they went through a balancing situation. The Canadian approach was really interesting because the Supreme Court here was interpreting a statute that is almost identical to the patent eligibility statute in the United States. In fact, the Canadian patent law was based on the U.S. patent law. So they're looking at the same words, whoever invents any new and useful, I think they've got art as well as machine, manufacture, process, et cetera. But looking at the same language, they don't have an explicit morality provision, but they said when we look at the words composition of matter and manufacture, those don't seem to encompass higher life forms, okay? A higher life form is more than just a combination of two or more ingredients. There are things that we can't account for in that, and we don't really think the Parliament had higher life forms in mind when they use those words. And if you take it broadly, a combination of two or more compounds, well, then it would make the other categories mostly redundant. A machine would be considered, an article of manufacture would be two or more compounds. And so they took the opposite approach and said, no, we really need explicit authorization from the legislature before we start granting patents on these types of life forms, higher life forms. So that's another way to do the ask questions first approach. Didn't last very long. Harvard case in Canada was 2002. Just 2 years later, we get the Monsanto v. Schmeiser case, which dealt with the patentability, in a sense, of another life form, higher life form, and that's plants. Excuse me. This was a case dealing with Percy Schmeiser, a canola farmer who had been growing conventional seed plants for 50 years. He did not buy genetically modified seed, but a lot of his neighbors did. And it appears, and from the undisputed facts, the court accepts that at some point seed did blow onto his property. He sprayed basically a 3-acre patch near the road or whatever with Roundup, and that's how he was able to determine that, because the plants didn't die, that there was Roundup-ready plants that had blown on, a seed that had blown onto his property. He harvested that seed, saved it, replanted it in a later year, thinking under normal property law, something wild comes onto your land, you get to keep it. But the court says no, ownership is no defense to infringement. Even though there were not claims to the plant. Okay, so remember from the Harvard Oncomouse case in Canada, the court said higher life forms, and that would include plants, are not patentable. But Monsanto did have claims to the chimeric genes, to the plant cells, and that was the basis of the infringement suit, that the plants that grow up have those chimeric genes and cells in them, and therefore Schmeiser is infringing. I don't know that I need to go through the technology with this group. I'll just, real quick, typical plant is sensitive to glyphosate, which is a herbicide. It basically kills everything green by deactivating this enzyme that plants need to grow. Monsanto discovered an enzyme that was resistant to glyphosate, and they inserted that into the DNA of various plants and came up with Roundup-ready plants. There's corn, there's soybean, quite a variety of them. Canola, excuse me. And so part of the challenge, though, is that since the gene shows up in the progeny of what's planted, Monsanto is still able to sue parties for infringement if they save their seed. So the court in the Monsanto v. Schmeiser case said that yes, Schmeiser did infringe by saving and replanting that seed. And ultimately, even though Monsanto didn't get any money, but it was not a terribly good case for farmers, since pollen flies and seeds get carried, and there are lots of ways that a field can get contaminated. So what we have in Canada is something a little strange, and it's just basically involves now patent attorney claim drafting tricks. You can't claim a higher life form, but if you claim a lower life form, you'll get protection for the higher life form. That's what they did, and the Q&A, if you want to know why, we can talk about that. All right, so even more recent case is the Organic Seed Growers and Trade Association versus Monsanto. And I'm also not trying to pick on Monsanto. They just kind of put themselves out there, okay? They're the biggest. They are the most aggressive in enforcing their patents. They have the most interesting cases. In the interest of full disclosure, I am on the board of directors of the Public Patent Foundation, which is bringing this suit against Monsanto on behalf of the organic seed growers. I was not involved in the decision to bring the suit. I don't have any involvement in the suit. I'm just letting you know. All right, so it's this suit by 80 plus organic farmers, as well as some conventional farmers who simply don't want to use genetically modified seeds and plants. They don't necessarily have an organic certification, but they are concerned about being sued by Monsanto for infringement. And so they are seeking from the court a declaratory judgment of non-infringement if they are contaminated by genetically modified seed. And they are also making a variety of arguments that the genetically modified seed patents are invalid. Excuse me. And farmers have so far not been terribly successful in litigating against Monsanto if the farmers choose to save seed, which is something farmers have done for millennia. And that's because in the United States, we recognize the doctrine of absolute product protection. Whatever product the patented invention shows up in, you infringe. This is from one of the Monsanto v. McFarling cases, where poor Mr. McFarling asserts that the unpatented germplasm and the second generation of genetically altered soybeans, the ones he planted the seed, the crop comes up, he harvests the seeds and plants them again, that's not a human-made invention, okay? But the court says the fact that germplasm and the soybeans are not human-made is irrelevant to infringement. What is human-made are the chimeric genes claimed in the 605 patent, which are found in all of the infringing seeds at issue in this case. Principles of patent law do not cease to apply when patentable inventions are incorporated within living things, either genetically or mechanically. And so this has been one of the big problems for farmers. Normally, with most products that are covered by patents, like my friendly BlackBerry phone, once I buy my phone, I can do whatever I want to with it, basically except completely remake it again. But I can give it to somebody else, I can sell it to somebody else, I can repair it if it gets broken. But with living things that self-replicate, what the court says is that first sale doctrine doesn't apply to the new progeny that grow because they have not been sowed before. And so that leaves farmers in the situation of having to basically buy this seed from Monsanto and other such companies every year. So this group of farmers, they have a lot of concerns. They don't have a way to tell if their fields are being contaminated. You can't look at these genetically modified plants and tell that they're different from the conventional ones. The only way to do it, especially if you're talking about Roundup Ready, is spray Roundup, and then you've killed your good plants as well as the genetically modified ones, or do some sort of lab analysis. No good way to unmix them either. One of the arguments that they're making, and I just thought this was really interesting, and I truly had nothing to do with this because I would have told them, I don't think that's a winning argument. I don't think there is a moral utility requirement. But nevertheless, they are arguing that these inventions lack moral utility. So reviving Justice Story's language again, and they're talking about all of the problems that genetically modified plants cause. The increased herbicide use, that we are now facing these horrible glyphosate-resistant weeds. There have been farmers who have had to just abandon fields. There are pig weeds that are so big they just break the combines that are unlucky enough to go over them. There's evidence that some of the toxins, like the BT toxins, studies showing that in the human bloodstream, and supposedly it was supposed to be destroyed by stomach acid, and that's not actually happening. And it's been hard to study what the effects of these plants are because Monsanto in particular limits the research that can be done on their patented inventions, and patents allow you to do that. So lots of problems that they've identified. And of course, exhaustion of patent rights, the USCATA is arguing that exhaustion should apply for a variety of reasons. There are, of course, benefits, or at least argued to be benefits, of these transgenic crops. This is from a National Academy of Sciences report that U.S. farmers are realizing substantial economic and environmental benefits, lower production costs, fewer pest problems, reduced use of pesticides, and better yields compared with conventional crops. There are a lot of folks who dispute those excuse me, findings that say that a lot of the benefits have actually come just from conventional improvements in conventional breeding. And with the rise that we're seeing in the resistant weeds, and having to go to higher use of insecticides, that they're actually creating lots of problems. Other things, loss of biological diversity. Again, if organic farmers can't keep this stuff from contaminating their fields, what's going to ultimately happen? Will we be able to have organic food free from genetically modified organisms in the future? What has already been discussed, the strict liability standard of patent law. It doesn't matter whether you intended to infringe or not. If you infringe, you're liable. Excuse me. And this stuff does move, and this is detailed quite well in the briefs that have been filed in the case. So this is, one of the things that I was looking at as I was studying this is, normally we as human beings, we get desensitized to controversial issues over time. So morally controversial things that seem so bad at the beginning, seem less and less bad as time goes on. It's a coping mechanism. But we are continuing to see these challenges to certain types of patents on patents on certain types of these morally controversial inventions. And I just found that very interesting. Why are we continuing to see these cases arise? It has such a different impact, I think, than in many other areas. When you think about food, when you think about dramatic changes to the way that people farm. This was from the governor of a district in Brazil, comparing what's happened there with farmers having to buy seed every year, reducing it to the situation of the Middle Ages. And what has allegedly happened in countries like Argentina, India, Monsanto will go in and many times offer the seed for free or very low cost to get people started, and then retroactively demand royalties. That's what I've read. So that's kind of problematic, too. And there's another problem. When I have my students read these cases, I also have them to write up response papers to help the discussion in class. And this was one that I got from one of my students. I thought it was really interesting. I'm not going to read this whole thing, but he was talking about the Schmeiser case. Down here, if Schmeiser can no longer collect his seeds, he must buy seeds every year instead of harvesting seeds for free. While this may not seem like a big issue, this may significantly impact his bottom line. The decision is being taken from him. While patent law seems to support the court's decision, there are many policy reasons for a finding of non-infringement. It's questionable whether patent law needs to protect Monsanto in this situation if the purpose of the patent system is to provide an incentive to innovate. In fact, Monsanto now has an incentive to create a seed that is better at pollinating neighboring fields because they know there's basically no liability for them and they're able to sue people for infringement. I'm like, wow, you're right. And that's scary. All right, so what are some of the consequences of these plant patent cases and patents on plants that we're seeing? There are a number of interesting things, and I only want to talk about the first three responses that we've been seeing. Narrowing of claim scope and subject matter challenges, like the organic seed growers case. That is, in effect, a subject matter challenge. They want to get rid of basically all of these genetically modified patents. One of the things that I find different about patents on living organisms, where we've had all of this controversy, is, in a sense, the backlash that we see against patent owners who choose to use the full exclusionary power of the patent law. So another case that's been going on, there's a petition for cert to the Supreme Court now that you probably heard about, is the ACLU versus Myriad Genetics case, involving the fact that Myriad has these patents on the breast cancer 1 and 2 genes, and Myriad has been very restrictive in controlling who can test, basically just them, can test people for the presence of this gene. And this is a challenge to the patent eligibility of all gene patents. Even though many other gene patent owners don't act the way Myriad does, they will license non-exclusively. Myriad's behavior affects all owners, or potentially affects all owners of patents in this category. Belgium is one company that's created a specific compulsory licensing regime, compulsory license for public health, basically to allow third parties to practice an invention without the patent owner's consent, and it was generated by the concerns about Myriad's practices. And then another one that I'll say a little bit more about is the Monsanto soy flour case in the European Union. So this is a case dealing again with Roundup Ready technology. This time it's soybeans. And Monsanto lost patent protection in Argentina, but they had already made a big push to get farmers to adopt Roundup Ready crops in Argentina. And apparently more than 50% of the land is sown in soybeans, 98% of which are Roundup Ready soybeans. And so Monsanto was not obtaining royalties there in Argentina, okay, for those seeds, because there's no patent. So what they chose to do was sue importers who were bringing the meal made from the seed into the European Union. And so they've sued importers, they've sued them in a number of different countries, the UK, Spain, Denmark. And this again is going to deal with the European Union Biotechnology Directive. And so the question, ultimately, the interpretation goes up to the European Union Court of Justice. So it's the same technology, but we now have a different step, because so the gene is beneficial when the plant is growing, so the farmer can spray glyphosate if they need to after the plant has emerged, if they've got a particularly bad weed infestation. But then once the soybeans are harvested and then they're turned into soy meal, the gene is still present. Okay? So Monsanto is arguing on the basis of absolute product protection, which, as I said, we have in the United States. You find that patented gene anywhere in any product, there's liability for patent infringement. Not so in the European Union. This biotech directive, where they have, it was very controversial. It took them 10 years to complete negotiation. There was much more input from civil society, from groups that were concerned about patents on life. And so there were various safeguards that were put in place and limits that were put in place. It was definitely about making clear that you could get patents on certain types of genetic material, like genes, things isolated from the body. But there are also things you could not get a patent on. And if you're going to get a patent on a gene, you have to disclose its function. Excuse me. Okay. And it was very controversial. Even after it was passed, several countries refused to implement it. The other countries took them to the European Court of Justice and sued them. It was crazy. All right, so there's a provision, Article 9, says the protection conferred by a patent on a product containing or consisting of genetic information shall extend to all material in which the product is incorporated and in which the genetic information is contained and performs its function. All right? So if you think about the function of the glyphosate-resistant gene, it is to protect the plant from glyphosate. When you get to the meal, it's not performing its function anymore, okay, because the meal is dead, and that's what the court said. No protection. There's no infringement here, where the patented product is the dead soy meal and it does not currently perform its function. So no absolute product protection for genes. And when this case came out, I'm like, oh, I bet those other biotech companies are mad at Monsanto for bringing this case and getting this decision really narrowly interpreting this biotech directive. And one of the arguments was that if Monsanto won, the jeans and T-shirts you're wearing that might have been grown from cotton in India that wasn't patent protected, but has that gene in it, patented gene, that Monsanto could sue people for the clothes they wear, because under absolute product protection, that gene is still present. I don't know if that actually influenced the court's decision or not, but it's a little scary to think about that. All right, so in terms of other consequences, that's one consequence, these challenges to subject matter eligibility, narrowing of claim scope. Not saying the European Court of Justice isn't saying anything about whether you can get a patent. You can get a patent, but it's just not that broad. Okay? You're limited in terms of how far you can go with enforcing it. There's an interesting article written by Jonathan Masura. It came out in the Yale Law Review last year, called Patent Inflation, where he talks about the expansion in the scope of patent-eligible subject matter that has been taking place over a couple of decades, and he ties it to the asymmetry between the Patent Office and the Court of Appeals for the Federal Circuit. And the Court of Appeals for the Federal Circuit is a court that hears all appeals in patent cases. And what he pointed out, he says, well, if an applicant's claim gets rejected at the Patent Office, they can appeal that decision to the Court of Appeals of the Federal Circuit, and the Court of Appeals might reverse the Patent Office and say, actually, you do have to grant that patent. But if the Patent Office grants a patent, then no one has the right to appeal the decision regarding grant to the Federal Circuit. And what that means is that encourages, in his view, that encourages the Patent Office to grant more patents, because who wants to be reversed, okay? It's easier for them to grant a patent, and to the extent that the Patent Office does reject patent applications, those are going to really be ones that are really pushing the boundaries of patent-eligible subject matter. And every once in a while, that should be CAFC, every once in a while the Court of Appeals for the Federal Circuit will say, yeah, that actually is patentable. And so then you go to a new level. That new precedent will influence other judges. It will influence the PTO. Cycle's going to begin again. And so he's like, we're just gradually getting broader and broader levels of patent-eligible subject matter because of this interplay between these two, this administrative agency and this judicial, this court. And I thought of an example. I don't know if this actually is this coming into play, but it seemed so to me. So let me get to, there it goes. All right, so there have been a number of patents issued on human cloning methods, or mammalian cloning methods. Excuse me. This is one that came out in 2004. Patent Office, U.S. Patent Office issues this claim, a method of cloning a mammal, not a claim to the cloned mammal, just to the method of cloning a mammal. But in times past, the Patent Office would not grant such patents. Okay? This is from a 1999 office action rejecting claims to a method of cloning a mammal. The examiner said methods of cloning humans are non-statutory, as it is Patent Office policy not to issue claims that are to or encompass humans. And you're like, well, it's a claim to the method. How does that encompass humans? How it encompasses humans is through this statutory provision, Section 271G, which says whoever imports, sells, or uses a product which is made by a process patented in the United States shall be liable as an infringer. So this provision, if gives the owner of a patent on a process, even if they don't have a patent on the product, the right to prevent imports of that product from coming into the United States. So you own a process on a method of cloning humans. Under this provision, you could stop cloned humans, okay? Think of them as embryos, fetuses, whatever, from coming into the United States. So in a sense, that process claim does encompass humans. And it used to be Patent Office policy not to grant such patents. Over time, now they're granting them. There's been no explicit notice of a change in policy. And I think that might be an example of patent inflation taking place. There's a statement came out not long after that patent was granted. Commissioner for Patents, John Dahl, Deputy Commissioner, I don't think anyone knows in terms of crude percentages how to differentiate between humans and non-humans. It'd be really helpful to have some guidance from Congress or the courts. Well, they don't really get any guidance. It's just too politically charged an issue. Oh, wait. I thought I had that other slide. Okay, well, I won't get to it. The only thing that they have gotten is the Weldon Amendment, which was mentioned earlier, that was actually codified into the Patent Act in the America Invents Act of 2011, back in September, which basically says that you can't grant a patent on an invention that encompasses a human. It does not tell us what a human is or what it means to encompass a human. So Patent Office still doesn't have a whole lot to go on there. Okay, I'm almost done. Woo, I'm almost out of time. Wow. Okay, sorry. Let me just, a couple of things here, because some things are really interesting, great to plant. So another really interesting article written by Sabrina Safran in 2007, Chain Reaction. She looked at the Diamond v. Chakrabarty decision and said that was really the trigger that caused a chain reaction in other people, other groups wanting property rights. Professor Johnson was talking earlier about traditional knowledge holders, those who know things about genetic resources, medicinal properties of plants, Hoodia, et cetera. And we have the Convention on Biological Diversity now that gives sovereign countries the ownership of genetic resources within their borders, which previously had been considered the common heritage of mankind. They're supposed to make access available on reasonable terms, but there's supposed to be benefit sharing that goes along with that. And so with patent law giving ownership rights to living matter, these other groups, not wanting to be left out, have sought rights on raw materials. And she says, why, these countries asked, should individuals and companies from gene-poor developed countries obtain genetic material free of charge from gene-rich developing countries when they then patent these genes and at times sell them back to the country where the genetic material originated? So what we get is more and more property rights over things that used to be common. It's a tit for tat, she argues, but it makes sense. And we've seen some ways that countries are incorporating these considerations into their laws. The third revision of the Chinese Patent Act, which went into effect in 2009, had a new provision. So they always had the first sentence, which is kind of like what we saw, the EPO morality provision: patents shall not be granted for inventions or creations that violate the law, run counter to social ethics, or jeopardize the public interest. What's new is the next part. If genetic resources are obtained or used in violation of laws or administrative regulations, and an invention or creation is complete on the basis of such genetic resources, the patent shall not be granted therefore. So if you don't get permission and you take a plant and try to isolate whatever compound and get a patent, well, you can't get a patent in China, okay, because you're not entitled to a patent if you did not go through the proper steps. India's Biodiversity Act is a little scary, but interesting. No person shall apply for any intellectual property right by whatever name. And not only that, look at the second paragraph. Whoever contravenes or attempts to contravene or abets the contravention shall be punishable with imprisonment. Okay, you can go to jail for filing a patent application on a genetic resource, biological resource that you did not get permission from. And just last week, Monsanto's patent, and it's Monsanto again, but I didn't make this stuff up. They're doing it themselves. They obtained a European patent on this melon plant that apparently originates in India, and it's resistant to this particular virus. Now, it's not genetically modified. Apparently, they made it using conventional breeding methods, but there has now been a challenge, an opposition that has been lodged at the European Patent Office to the grant of this patent. You get 9 months after patent issues to oppose a patent in the European Patent Office, and so that's what these folks are doing. Just filed it last Friday. And one of the things they're saying is the claim isn't patentable under Article 53A. It's also violates provisions of the Indian Biological Diversity Act, because they said Monsanto didn't get permission before they took the melon and started doing whatever research on it. So I don't know where that case is going to go, but it's part of this chain reaction that we're seeing. And this stuff isn't ending. This is this coalition that is opposing this patent. Since March of last year, more than 250 organizations, 53,000 individuals have signed a petition, no patents on seeds. It's not ending. It's not stopping. All right, I'm almost done. So, there are arguments on both sides. Monsanto, DuPont, Syngenta, Bayer, they all invest a lot of time and money into coming up with this technology. Roundup Ready soybeans did not exist except by science. It was man-created. We took something that would not have occurred without our efforts and intervention, and we created something of much higher value in this country that qualifies for a patent. It absolutely does. Whether or not it should is something I guess Ed's going to argue tonight, that it absolutely should. But there are questions about whether or not it should. This is a quote from the dissent in the Monsanto v. Schmeiser Canadian decision, Justice Arbour. She said, because higher life forms can reproduce by themselves, the grant of a patent over a plant, seed, or non-human animal covers not only a particular plant, seed, or animal soil, but also all its progeny, containing the patented invention for all generations until the expiry of the patent. In addition, much of the value of the higher life form derives from the natural characteristics of the original organism and has nothing to do with the invention. In light of these unique characteristics of biological inventions, granting the patent holder exclusive rights to extend not only to the particular organism embodying the invention, but also to all subsequent progeny of that organism represents a significant increase in the scope of rights offered to patent holders. It also represents a greater transfer of economic interests from the agricultural community to the biotechnology industry than exists in other fields of science. I think these are really important concerns that need to be taken into consideration. They're really not right now in the courts. And this is a final quote from a United States Supreme Court decision. Patents are matters concerning far more than the interests of the adverse parties. Possession and assertion of patent rights are issues of great moment to the public. A patent by its very nature is affected with a public interest. As recognized by the Constitution, it's a special privilege designed to serve the public purpose of promoting the progress of science and useful arts. At the same time, a patent is an exception to the general rule against monopolies and to the right to access to a free and open market. The far-reaching social and economic consequences of a patent therefore give the public a paramount interest in seeing that patent monopolies spring from backgrounds free from fraud or other inequitable conduct, and that such monopolies are kept within their legitimate scope. And I think what we're seeing happen with these cases regarding plants is the public clearly taking a strong interest in what is happening here, and saying that perhaps we're going a little bit too far. So I think the public will continue to have an interest in plant patenting, and challenges to plant patents are likely to continue. Thank you.